There is a particular kind of silence that shows up in institutions right before they do something they've been putting off for a very long time. The silence right before a judge signs an order. The silence right before a board finally fires the founder everyone's been protecting. The silence right before a family finally stops making excuses for the relative nobody wants to talk about at dinner. It's not a dramatic silence. Nobody's shouting. There's no press conference. It's just a piece of paper that shows up one Monday morning, one sentence long, and by the time anyone's finished reading it, an entire chapter of a very expensive, very public fight has been closed forever. That's roughly what happened this week. Hi, welcome back. Good to have you here. Settle in, because this one's got layers, and I promise by the end of it, you'll understand why a single unsigned, unexplained sentence from 9 people in Washington might end up being one of the more consequential paragraphs of Donald Trump's second term, and not for the reason most headlines are giving it. I'm Marcus Fenn, this is Borderlines, and we're going straight into it, because the story underneath this story is the one nobody's really told you yet. Here's what technically happened, and I want to get the technical part out of the way quickly because the technical part is not actually the interesting part. Back in 2023, a jury in Manhattan looked at the evidence in a civil case brought by the writer E. Jean Carroll, deliberated for a little under 3 hours, and concluded, unanimously, 6 men, 3 women, that Donald Trump had sexually abused her in a department store dressing room in the 1990s, and then defamed her in 2022, when he called the allegation a hoax. $5 million in damages. Trump denied it, appealed it, lost the appeal, and then did something almost nobody does, which is ask the Supreme Court to reconsider its own refusal to hear the case. Courts call that a petition for rehearing. It is, and I want to be precise about this because precision is going to matter later, one of the rarest procedural moves in American law. The Supreme Court had not granted one since the 1960s, not rarely granted, not granted at all, for 60 years. And on Monday, in a single sentence with no explanation, and this is the detail that actually matters, no noted dissents, the court said no. Not a single justice, including the 3 Trump himself appointed, filed so much as a footnote of disagreement. Carroll's lawyer put it about as plainly as a lawyer is allowed to. The verdict is now final, and it cannot be challenged in any court ever again. Trump had already paid the money, by the way, $5.6 million, with interest, quietly wired over the summer while everyone was looking at tariffs. So, on paper, this is a footnote, a formality, the final flourish on a case that was already over in every way that mattered. And if that's all this was, I wouldn't be spending 20 minutes of your life on it, because a footnote is a footnote, and you didn't come here for footnotes. Here's why it isn't one. This wasn't really ever about $5 million. $5 million is, and I say this with real affection for how strange it is to type this sentence, essentially a rounding error to Donald Trump's legal operation this decade. The number was never the point. The point, and this is the thing his lawyers were actually trying to accomplish with a petition they had to have known was almost certainly going to fail, was precedent, was leverage, was a dry run for a much bigger, much more consequential fight that is sitting on the Supreme Court's docket right now, waiting, largely unnoticed, while the country argues about literally everything else. Because there is a second Carroll case, a bigger one, $83.3 million bigger. And that one is not over. That one is the actual fight. And what happened this week tells you almost everything you need to know about how it's going to go, which is, I promise you, not what Trump's legal team is hoping for. And here's why. Let's back up, because you need both cases side by side to understand what's actually being fought over. And it is not what most coverage of this made it sound like. Carroll sued Trump twice. The first suit, the one that just finally permanently concluded this week, was over statements he made in 2022 after he'd left his first term and before he'd returned to office. Private citizen Trump essentially, mid-defamation, on his own social media platform, calling a woman who'd accused him of assault a liar in writing, repeatedly. Straightforward. No special legal shield applies to a private citizen posting on Truth Social. The second suit, the one still alive at the Supreme Court, is about something he said back in 2019, while he was sitting president, denying an earlier version of the same allegation at, of all things, a press conference. Same underlying facts, same accuser, same basic behavior, deny, insult, repeat, but a different legal costume, because this time, his lawyers get to reach for the single most powerful shield available to any American president, the argument that when you're doing the job, you get almost total immunity for what you say and do in the course of doing it. And that argument isn't hypothetical anymore. It isn't theoretical. It's been tested, and it won, spectacularly, in the most consequential ruling of Trump's entire legal career, the 2024 Supreme Court decision in Trump versus United States, which found that a president enjoys sweeping immunity from criminal prosecution for official acts. Not defamation, not this case specifically, a different case entirely about January 6th, but the same 6 conservative justices, the same expansive reading of what counts as official, and Trump's lawyers are now trying to walk that same argument straight into a defamation courtroom and see if it holds up there too. Answering a reporter's question at a White House podium, they're arguing, is about as official as a presidential act gets. Therefore, and I want you to sit with the actual shape of this argument for a second, therefore, telling a provable, deliberate lie about a woman he was found, by a jury, to have sexually abused should be legally untouchable, simply because of the room he happened to be standing in when he said it. Now, of course, courts have already looked at this exact argument, twice at the trial level and on appeal, and both times the answer was the same: no. Answering questions at a press conference might be an official duty. Lying about assaulting someone you actually assaulted is not, by any reasonable definition, a function of the presidency. The trial judge in both Carroll cases, same judge, by the way, Lewis Kaplan, presiding over both trials, ruling on the same underlying legal questions in both, including, notably, letting a jury in both cases hear the Access Hollywood tape, because Trump had, in his own recorded words, described exactly the behavior Carroll alleged as something close to routine for him. That judge has already rejected the immunity defense once. The appeals court rejected it too. So, what Trump is actually asking the Supreme Court to do with the $83 million case isn't really hear new evidence or correct an error. It's asking 9 people to redraw, again, the outer boundary of what a president can get away with while claiming he was just doing his job. And this week's ruling, on paper unrelated, on paper just closing out the smaller case, is actually the closest thing we have to a preview of how that's going to go. Because if the justices, including the 3 he appointed, including the ones who handed him the immunity win in the first place, weren't willing to give him so much as a sympathetic footnote on a case with none of the immunity complications, a case where the president was just doing his job, argument literally doesn't apply because he wasn't president when he said it. That tells you something about the ceiling on the sympathy available for the harder version of the argument. It's not proof. Courts have surprised people before, and this particular one has a well-earned reputation for expanding presidential power in ways that would have made law professors from 20 years ago spit out their coffee. But it's a data point, and it's not the data point Trump's legal team wanted heading into the bigger fight. Here's the part of the story that I think deserves more attention than it's getting, and it's not really about the court at all. It's about what this pattern says about the strategy underneath it. Because this is not the first time Trump's approach to an unfavorable legal outcome has been to simply keep asking, in slightly different language, until either the venue changes or somebody says yes. Appeal, then request an en banc rehearing at the circuit level, then petition the Supreme Court, then, when that fails, petition the Supreme Court to reconsider its own petition denial, a move so procedurally unusual that legal reporters had to go back to the Eisenhower administration to find a precedent for it succeeding. That is not the behavior of someone who believes the underlying facts are in serious dispute. 6 jurors sitting in a room, hearing all the evidence, took less than 3 hours to reach a unanimous verdict. That is not a coin flip. That is not he said, she said. That is a jury looking at a mountain of evidence, including the defendant's own recorded voice describing exactly the conduct at issue, and needing less time to decide than it takes to watch a football game. What kept this case alive for years afterward was never the strength of the defense. It was the depth of the appellate ladder. and a defendant with functionally unlimited resources and functionally unlimited motivation to keep climbing it, for as long as climbing it kept the story ongoing litigation instead of settled fact. And that strategy worked for a while, in the sense that it worked for delay. It did not work this week in the sense that mattered, which is that the latter has now run out on the smaller case, permanently, with the loudest possible silence from every justice who might have been expected to help. Let's talk about what this actually costs the country, because that's the part that tends to get lost underneath the individual courtroom drama, and it's the part I actually think matters most here. When the head of state of the most powerful nation on earth spends years of his term, first term and second, cycling through appellate courts trying to overturn a jury's finding that he sexually abused a private citizen and lied about it, that is not a private legal matter that happens to involve a famous person. That is the executive branch's own occupant treating a final, unanimous jury verdict as an ongoing negotiation, right up until the machinery of the judicial system physically will not let him negotiate anymore. And there's a cost to that beyond the individual case. Every time this argument gets extended, every time official acts get stretched to cover a press conference denial of a sexual abuse allegation, it doesn't just affect Donald Trump. It sets the shape of the shield for every president after him, of either party, for as long as the precedent stands. That's the actual stakes of the $83 million case sitting on the docket right now, dressed up as a dispute about money. It's not a dispute about money. $83 million is not a sum that meaningfully changes Donald Trump's life. What's actually being litigated is how much of the presidency can be quietly reclassified as a consequence-free zone, one favorable ruling at a time, and whether "I said it from behind the podium" becomes a phrase with genuine legal magic attached to it. If the court extends the immunity logic that far, the practical result isn't really about this case at all. It's a permission structure. It tells every future occupant of that office that certain categories of lying from that specific podium come with a legal moat around them that an ordinary citizen, or even that same person acting as a private citizen, simply does not get. Which is, if you think about it for more than a few seconds, a genuinely strange thing for a system built on the idea that no one is above the law to be seriously debating. Now, the other side of this, and I try to be fair about the other side even when the other side has had a rough week, the argument Trump's lawyers are making is not, strictly speaking, insane on its face. Presidents do need some latitude to answer hostile questions without every syllable becoming a defamation lawsuit. You don't actually want a world where a president has to run every press conference answer past outside counsel first, because that would make the office functionally unable to communicate with the public at all. And there's a real serious version of that argument that thoughtful people who are not remotely Trump supporters have made in other contexts. The problem, and it's not a small problem, is that the specific speech at issue here isn't a policy opinion or a characterization of a contested event. It's a factual denial of conduct a jury later found, unanimously, to have actually happened, twice across two separate trials, years apart, with two separate juries reaching the same conclusion on the same core facts. The immunity argument, taken to its logical end, would mean a president gets extra legal protection specifically for the act of publicly lying about assaulting someone, so long as a reporter happened to ask the right question at the right podium. That's the actual argument being weighed, stripped of the procedural language, and it's worth sitting with how much distance there is between give the president room to answer hard questions and give the president a legal shield for denying a jury-established sexual assault. So, where does this actually leave things, heading into whatever comes next? The smaller case is finished, permanently, with a silence from the bench loud enough to be its own kind of statement. Carroll has her money. The historical record, as her attorney pointed out, can no longer be relitigated in any American courtroom, which is a specific kind of finality that very few plaintiffs against very powerful defendants ever actually get to enjoy. The bigger case is still out there, still pending, still unresolved, and the court hasn't said when or whether it will even agree to hear it, with most observers not expecting an answer before the fall at the earliest. And in the space between now and whenever that decision comes, Donald Trump gets to occupy a genuinely unusual position for a sitting president. Permanently, unappealably, on the record as a jury-adjudicated abuser and defamer in one case, while simultaneously arguing, in a separate case with nearly identical facts, that the presidency itself should have shielded him from the second half of that same finding. Both of those things are true about the same man, in the same set of facts at the same time, and the only variable separating them is which side of the inauguration he happened to be standing on when he said the same kind of thing twice. That is not a legal technicality. That's the entire ballgame. And it's worth remembering, the next time somebody tells you the presidency doesn't change what a person can get away with, that we are currently running a live, national-scale experiment specifically designed to find out whether that's actually true. I'm Marcus Fenn. This is Borderlines. This channel is just getting started. And if you think stories like this deserve to be tracked properly instead of buried under the next news cycle, subscribe and stick around, because the quiet rulings tend to matter a great deal more than the loud ones.